Hello and welcome to the basics of pleading, or how Hannah Harris should have answered the complaint. In the sidebar, we will cover what pleadings are, the key parts of basic pleadings, and what pleadings do. I'm Sherry Runner for Law U America. Before we get started, here's a little bit of fine print, which basically says this is not an exhaustive analysis of all of the issues that are presented in this situation. We're just keeping it basic for purposes of this introductory sidebar. Next up, what pleadings are. So what is a pleading anyway? A pleading is a formal document in which a party to a legal proceeding states claims or responds to claims and asserts defenses. Pleadings include complaints, answers, and sometimes replies. There are other pleadings as well. However, any discussion of those is beyond the scope of this sidebar. All issues to be resolved in the legal proceeding must be set forth in the pleadings. There are some exceptions to that general rule, but once again, that is beyond the scope of this sidebar. It's worth noting that pleadings are not motions. Even though they look alike, pleadings and motions have different purposes. And to illustrate the point, I've copied Rule 1.100 from the Florida Rules of Civil Procedure. If you're in another state, I encourage you to go online and find your state's Rules of Civil Procedure. And I'm pretty sure that you're going to find a rule or rules that are similar to this one here. The word pleading also refers to that early part or stage of a lawsuit in which the action is initiated and the issues to be resolved are framed. The pleading stage is when the pleadings are filed. Next up, what pleadings do. The complaint is the pleading that the plaintiff files with the court to initiate the lawsuit and in which the plaintiff writes his or her version of the facts and legal basis for the claim. The answer is the pleading that the defendant files in response to the complaint, in which the defendant states his or her agreement or disagreement with the plaintiff's allegations and sets forth defenses to avoid liability. Issues to be resolved in the lawsuit are framed by comparing the complaint and the answer to see where the parties' versions agree and where they diverge. The issues to be resolved, as elucidated in the pleadings, establish the focus of the lawsuit, the boundaries of the dispute, and the judges' and jury's jobs. Next up, key parts of basic pleadings. Using the Swamp Rose complaint as our example, at the very top of the first page, we see the name of the court. Below that is the case number, which is assigned by the clerk of court when the case is initiated, the name of the plaintiff, and the name of the defendant. And those parts together make up what's called the case caption. Beneath the case caption, the title of the pleading, a brief introduction to the pleading, and then a series of numbered paragraphs. And in this complaint, they're organized into two counts or causes of action. There are ad damnum or wherefore clauses at the end of each count, which just state the relief that the plaintiff is looking for, the date of the pleading, and signature with required contact information. And there's the complaint. It's neat, it's clear, and it's easy to understand. So, how should Hannah have answered the complaint? This is how Hannah answered the complaint. She wrote a letter to the judge explaining her side of the story. But this is how she should have presented her answer. You can see that it looks a lot like the complaint does, and there's a reason for that. And so we're going to actually compare the complaint and the answer side by side so you can see what's going on here and how they work together. So the case captions are the same and will be used on everything that's filed with the court for the rest of the case. Okay, of course, then there's the title, and then a short and to-the-point line of introduction. The pleading magic happens in the numbered paragraphs. The issues for trial are formed when the complaint and answer are read together, and that's what we're doing next. But first, we need to take a minute and look at appropriate answers to individual allegations in a complaint. Generally, a defendant answers individual statements in one of three ways. She either admits the truth of the statement, denies the truth of the statement, or states that she doesn't have enough information to either admit or deny. And here's why those responses are important. Any statements or allegations that a defendant does not deny are deemed admitted. The plaintiff has the burden of proving at trial the truth of the statements and allegations that the defendant denies. The plaintiff is not required to prove at trial statements or allegations that the defendant admits. If a defendant admits all the plaintiff's allegations, then there's no need for a trial. If a defendant denies all the allegations, the defendant risks losing credibility in the eyes of the judge. Let's take a close look at the individual complaint allegations and responses. This is paragraph 1 from count 1 of the Swamp Rose complaint. Paragraph 1 reads, "This is an action to evict a tenant from real property in Alachua County, Florida." And there's nothing really to dispute in that paragraph. You might not agree that that Swamp Rose should have or needed to sue Hannah Harris, but regardless, the allegation itself is a true statement, and so it's admitted. Paragraph 2, plaintiff owns the following described real property in the county, and then the address is recited. Now, if that's a true statement, of course, it's just admitted. And we're assuming here, because it's admitted, we're assuming that Hannah Harris did her due diligence before signing the lease or paying any money to Swamp Rose to make sure that Swamp Rose actually was the landlord. However, if Hannah hadn't done her due diligence before signing the lease, she might not have enough information to admit or deny the allegation about ownership. Her best answer then would be, defendant is without sufficient knowledge to admit or deny the allegation. Therefore, the allegation is denied. Now, this denial down here is actually very important because it will require Swamp Rose to prove that it owns the property. What if some other entity or a person was the actual owner of the property, but Hannah didn't know that? If Hannah didn't deny this allegation, then she would miss out on a potential opportunity of having the case dismissed. Paragraph 3, defendant has possession of the property under a written agreement to pay rent. That allegation is factually true, so it's admitted. Paragraph 4, defendant made material alterations to the property without first obtaining plaintiff's consent in violation of paragraph 17. Hannah takes issue with the characterization of the situation, and so the allegation is denied. Paragraph 5, then defendant failed to pay the full amount of rent due. Hannah Harris, of course, takes a position that she wasn't required to pay the full amount of rent, and so the allegation is denied. Paragraph 7 of count 2 reads, this is an action for damages that do not exceed $15,000, and this is admitted because it's the same as in count 1. Regardless of how you feel about the lawsuit itself, this is a factually true allegation. It's admitted. Paragraph 8. Plaintiff restates those allegations contained in paragraphs 1 through 6 above. This is a very common paragraph that you'll see in complaints that have multiple counts or causes of action. The best response is something that just mirrors the paragraph and reads something like this. Defendant restates her responses to those allegations contained in paragraphs 1 through 6 above, and that just makes sure that whatever was admitted before remains admitted, and anything that was denied remains denied. Paragraph 9. Defendant owes plaintiff $126.91, etc. Hannah Harris disputes that, and so it's denied. Wherefore, plaintiff demands judgment for damages against defendant, and here defendant, in response, requests judgment in her favor. And just pointing out once again that the denial of paragraph 9 means that Swamp Rose will have to prove the truth of this allegation at trial. And here's something that is present in the answer, but is not included in the complaint. Certificates of service state when and how you serve a copy of the pleading, motion, or other paper on the other party or parties. Initial complaints do not have certificates of service because they are served with summonses and process servers. And once again, here's Hannah's response to the complaint, again, in the form of a letter to the judge. And now you can see how where the plaintiff and defendant agree and disagree is much more difficult to discern from something like this, as opposed to something like this, where it's very clear and easy to understand. And that's it. I do hope that you were able to get some useful information from this sidebar. Please visit our support page for ideas on how you can support LawU so we can continue in our mission to help bridge the access to justice gap. Thank you.